When the government promises to preserve family unity, why does that promise apply only to some families? Humanitarian programs like Parole in place protect certain spouses of US citizens from deportation, but only if their citizen spouse served in the military. What justifies drawing that line when the threat of separation feels no less devastating to other families? The Equal Protection Clause was written to ensure that the law does not arbitrarily favor one group over another. It is a guarantee rooted in the aftermath of slavery and civil war, meant to shield individuals from legal structures that entrench inequality. At its core, it demands that similarly situated people be treated alike unless the government has a compelling reason to do otherwise. But over time, that guarantee has narrowed. Courts now defer heavily to the government in areas like immigration and military policy. They uphold distinctions so long as any rational justification can be imagined, and often require proof of discriminatory intent to even question them. As a result, laws that produce real and lasting inequality can escape meaningful review. Today, we explore how that happened, and why it's time to ask more of equal protection than it currently asks of itself. The existing equal protection doctrine rests on a three-tiered structure that courts apply with consistency. Classifications involving suspect classes listed in the 14th Amendment, like race, and quasi-suspect classes, like sex, receive heightened scrutiny, while all other distinctions are evaluated under a deferential rational basis review. Within that structure, the PIP program, which benefits only spouses and family members of military personnel, is easily upheld as a rational means of supporting military readiness. It is neither facially discriminatory on suspect grounds, nor directly restricts a fundamental right. So courts apply minimal scrutiny and defer to policy justifications. However, this creates a selective equilibrium. Certain groups, like military families, are extended affirmative legal protections based on their social value, while similarly situated people, like non-military spouses of United States citizens, are categorically excluded. Equal protection, under this logic, becomes a tool of validation for narrow policy goals, not a principle of universal legal inclusion. As citizens, we must recognize that this equilibrium is not mandated by the Constitution. It is the result of doctrinal choices that can and should evolve to reflect a broader conception of legal equality. By design, the PIP program conditions relief not on conduct, merit, or individual equities, but on lineage, specifically whether one's spouse, parent, or child has served in the military. This seemingly neutral criterion has a self-reinforcing effect. Individuals who, due to circumstances beyond their control, are not connected to the military are per se ineligible, no matter how compelling their humanitarian circumstances. This includes elderly immigrants, disabled persons, caregivers, and even conscientious objectors. The result is a two-tier system. One group, military families, is protected by a humanitarian doctrine rooted in family unity. The other group, non-military families, is structurally excluded from the same protection, even when their circumstances are indistinguishable in principle. The Equal Protection Clause does not prohibit line drawing per se, but it cannot endorse arbitrary exclusions that reinforce inherited inequality. Our argument, then, is not to invalidate PIP, but to extend it, to dissolve this structural asymmetry and fulfill the constitutional promise of equal protection for all spouses of United States citizens, regardless of lineage. The Supreme Court's reasoning in Students for Fair Admissions versus Harvard, back in 2023, revived a strong version of equal protection rooted in individualism, rejecting classifications based on ancestry or lineage, even for benign purposes. This logic, while applied to racial classifications, reflects a growing discomfort with governmental favoritism based on inherited status. And yet, PIP continues to do just that. It allocates a vital legal benefit, parole, based not on individual hardship or contribution, but on one's familial relationship to a service member. This raises a deeper question, not just about lineage, but about how the law selectively protects a right the court has long held fundamental, the right to marry. The Supreme Court has repeatedly held that marriage is a fundamental right, central to individual dignity, autonomy, and full participation in civic life. That protection has never been limited to the formal act of marriage alone. In cases such as Loving versus Virginia, Zablocki versus Redhale, and Turner versus Safley, the court recognized that laws which substantially interfere with the ability to sustain a marital relationship through legal insecurity, conditional recognition, or forced separation implicate the Constitution even when marriage is not expressly prohibited. The right to marry includes the right to have that marriage meaningfully recognized and protected by law. Current equal protection doctrine, however, often fails to protect this right when the burden is indirect or selectively imposed. In the immigration context, courts routinely reframe marriage-based claims as disputes over discretionary benefits owed to non-citizens, rather than as challenges to unequal treatment of U.S. citizens' marriages. This doctrinal move obscures the constitutional injury. When the government secures family unity for some citizen marriages but denies it to others, it is not merely allocating benefits, it is differentially protecting a fundamental right. Parole in place illustrates this failure. By extending immigration relief to spouses of U.S. citizens only when a military affiliation exists, the government conditions the legal stability of marriage on lineage, unrelated to the marital relationship itself. Two marriages identical in every constitutionally relevant respect receive radically different treatment. The current doctrinal tests obscure this disparity by looking for formal prohibitions or animus, rather than recognizing when a fundamental right is selectively denied. The result is a regime in which the right to marry is acknowledged in principle, but secured only for some in practice. Where the government protects a fundamental right for some but not others, equal protection doctrine has historically favored extension, not withdrawal, as the constitutionally appropriate remedy. Extending PIP to all spouses of U.S. citizens would resolve this doctrinal inconsistency by honoring the Constitution's command to treat similarly situated individuals with equal dignity under the law. Modern equal protection doctrine, as it stands, requires proof of discriminatory intent before courts will seriously scrutinize laws that produce unequal outcomes. As a result, facially neutral laws, like PIP, are shielded from challenge even when they create persistent structural inequality. This framework is, quite frankly, the legacy not of Brown versus Board, but of Plessy v. Ferguson, where the court ignored the real-world consequences of separate but equal in favor of formal symmetry. Today's intent doctrine makes the same move. It treats exclusionary policies as constitutionally sound, so long as they are neutrally phrased and well-intentioned. This doctrinal bottleneck has paralyzed the Equal Protection Clause. Courts keep demanding evidence of malicious purpose, all the while ignoring the actual systemic effects. So, in practice, caste-like exclusions survive under the guise of policy preference. But the 14th Amendment was designed to eliminate legal structures that entrench unequal protection, not just bad motives. If PIP were challenged on equal protection grounds, courts would likely find no animus. But that is not the problem. The real problem is this structural invisibility of non-military families, families who are identically situated in terms of need, dignity, and their relationship to United States citizens, yet they receive none of the law's protection. Recognizing this doesn't require invalidating PIP. It requires expanding it. consistent with the original meaning of equal protection. Our goal is not to strike down a program that supports military families, but to recover what the Equal Protection Clause was actually meant to do: protect people from unjust legal exclusion. When it was ratified in 1868, equal protection was understood as a substantive safeguard. The government simply could not impose unequal burdens or withhold legal protections from one class of people while granting them to another, unless there was a compelling reason. The focus back then was on outcomes and systems, not just intentions or statutory text. Restoring this vision would mean holding the government to account not just for what it says, but for what its laws actually do. If PIP promotes family unity for United States citizen families connected to the military, that goal is legitimate. But the principle of family unity is no less important for the spouse of a United States citizen who is a teacher, nurse, or farm worker. Our position is simple. No American spouse should have fewer legal protections because of whom they married or whom they didn't. To apply the Equal Protection Clause faithfully is not to dismantle programs like PIP, but to extend their protections in a way that eliminates arbitrary exclusions consistent with both constitutional text and national values. One reason the PIP program has remained constitutionally unchallenged is that it sits at the intersection of three highly deferential domains: military policy, immigration enforcement, and rational basis review. Courts typically defer to the executive in matters of national defense and immigration, assuming that line drawing in these arenas is, more or less, immune from meaningful equal protection challenge. But when all three deference doctrines converge, they create a constitutional blind spot, a space where systemic inequality can thrive, shielded from scrutiny. This is where equal protection must reassert itself. Deference cannot become a license for unequal legal recognition. The Constitution does not exempt any domain, military, immigration, or otherwise, from its command that the law protect persons equally. We do not ask the court to second-guess national security priorities or rewrite immigration law. We ask that where the government has chosen to create a humanitarian benefit, as it has with PIP, it must administer that benefit even-handedly when similarly situated people are involved. Spouses of United States citizens, regardless of military connection, are not outsiders to the law. They are the very people equal protection was designed to include. The Equal Protection Clause is not a doctrinal puzzle or a bureaucratic formality. It is a moral and legal commitment to ensure that the laws of this country do not divide, exclude, or ignore classes of people without good reason. The Parole in Place program serves a laudable purpose, but its current structure violates that commitment by arbitrarily restricting access to a vital humanitarian protection based on lineage. We do not argue that PIP must fall. We argue that its promise must rise, that the law must extend the same protection to all spouses of United States citizens, military or not, in order to fulfill the Equal Protection Clause's text, history, and constitutional purpose. That is what justice requires, and it is what the Constitution commands.